Good afternoon. My name is Marielle Parker. I am a member of the Board of Directors of the Myositis Association, and I'm pleased to welcome you today to the session, Financial Self-Care, Easy Estate Planning for All Budgets. We are blessed today to have attorney Megan Campbell here to talk with us about estate planning and all of the perils that one can come across as we get older. We need to prepare for the inevitable, for ourselves, for our loved ones. And I personally am here as an active member of this association because my father had inclusion body myositis, and for many, many years, my family, my mother who's here, my daughter who is a volunteer outside who's 15, and myself were his caregiving team. We all lived together in a house, and my father and I, he was an attorney. He had businesses, and we operated businesses together. So we thought that we knew all the ins and outs and all the right things to do as we prepared for his aging process and his disease process. And then he passed away. And I learned as his executor that I didn't have everything prepared necessarily. A lot of things we were in good position, but a lot of things I wish I had known in advance. So that brings us to where we are today. I'm glad to be able to receive this information, as well as I'm sure you are, so that we can just do the best we can to prepare in advance and not look back and say, gosh, I wish I had known that. So with that said, we will welcome Attorney Campbell, and what we'll do is take her presentation, and then at the end we'll have some questions and answers. I'll bring the microphone to you, and we'll just have a dialogue. Thank you so much.
All right, thank you everybody. Welcome. So my name is Megan Campbell. I am an attorney here in Maryland. I run Willow Legal Group, which is out of Laytonsville, so about 20 minutes outside of DC. Let me give a short legal disclaimer, because lawyers always have to do that. We're going to talk generally about estate planning. Every state has different estate planning laws, so one of the things that I have up front here afterwards is if you don't live in Maryland and you want to be connected with an estate planning attorney in your state, near your city, give me your name and where you're located, and I will help connect you. I find often one of the hardest pieces with doing estate planning is people don't know where to start. It is overwhelming. Go, oh my gosh, it's so much to think about. And I've already got a million things going on. And so just trying to get that first step and finding an attorney who can help walk you through the process is really helpful. So, actually, before we start that, let's start with who has an estate plan in place. So, good. You're not, for those of you that don't, you are actually in the majority of Americans. 66% of folks in the US don't have any plan in place. And the problem we see mostly with that is if you don't have a plan, the state you live in has a plan for you. And so the state is going to make decisions on what they think might be best for you, which is oftentimes not what you want, right? And even in situations where it might be, right, when we talk about healthcare or decisions, defaulting to a spouse, or, if you don't have a spouse, a sibling, right? Sometimes that's what you want. But the minute there is any conflict, a hospital is going to say, not touching that, please go to court and let the court decide what happens, which then leaves you in the hospital. Hospital's keeping you alive until the court takes its time to figure out who gets to make the decision for you. And I don't know about you, but I would like to stay in control of my own life. I want to know who's making those decisions. I don't want a judge making decisions for me, right? Because one, I don't have the time to get to know you and your situation. And two, they're human, right? So they're gonna make a decision based on what they see on paper. And we all know people that look really good on paper, but it wouldn't be the people that you would want to make decisions for you, right? Or they might look great on paper, but their life is a hot mess. And so those are not the people that you would choose. So a big part of estate planning is staying in control. making decisions and having your decisions control rather than a judge or a stranger's. So, going into that, what is an estate plan? What is estate planning? Really, everyone over the age of 18 should have some sort of plan in place, right? Because we never know when we're gonna end up in the hospital. When are you gonna have a car accident, right? And COVID showed us this, more than anything. We had folks that ended up, perfectly healthy otherwise, ended up in the ICU, and someone has to step in and control your life at that point, right? If you aren't able to make financial decisions or healthcare decisions, someone needs to step in. So part of an estate plan is controlling your property. The other one is providing for yourself and your loved ones. Again, having that control of who gets what. And then talking about or thinking through minimizing the impact of court fees, professional fees, and other costs related to estate planning. So the documents included in a typical estate plan will be a will or a revocable living trust. The difference between the two is, do you go through the court process of probate or not? Healthcare directives, right? Or healthcare power of attorney. Who's gonna make medical decisions on your behalf when you can't? And what are those decisions? What do you want people to do if you're unable to speak and advocate for yourself? That's that living will. And then the last one is the financial power of attorney. Who is going to keep your financial life going when you can't? If you're hospitalized for an extended period of time and no one has access to your bank accounts and no one can pay your bills, who's gonna step in to do that? So the first thing to talk about is that incapacity planning, right? Incapacity could be cognitive decline, right? Folks that have Alzheimer's or dementia and can no longer manage their financial life. It can also be if you're hospitalized for an extended period of time and can't manage those decisions. Oftentimes we think of this as older individuals, but as I mentioned before, you never know when you're gonna end up in that car accident, right? You never know when you're gonna end up hospitalized for an extended period of time and not be able to manage your life on your own. So healthcare directives, who do you want to make healthcare decisions? If that person can't make a decision, who's the next person in line? Who's the next person in line? We tell our clients we always like to see 3 people named. So you have backups and you remain in control for who gets to make those decisions for you. Who can access your medical records? So HIPAA authorizations allow folks to be able to find out medical information about you, but not make medical decisions. So perhaps you have a number of siblings that you want them to be able to call and find out how are you doing, what's going on, but they are not people you would ever want to be able to make a decision. And then finally, as you make end-of-life decisions or as you near that point, what decisions do you want to have made? And this one is really the best gift that you can give your family. Because if you're in that situation, right, whether it's you've lived a long life and you're nearing the final days, or a tragedy has happened and your family has to make a decision, giving them guidance on what you would have wanted is a great gift because it allows them to know with certainty that that's the decision you would have made. And they're not second guessing, gosh, did I make the right decision? Because on top of grief, having that second guessing, compounds that grief. So, and then financial powers of attorney are very similar, but these are the people who can manage your financial and legal life when you can't. There are 2 types of financial powers of attorney. One is effective immediately. So it can, once you sign it, it can be used by the individuals named. The other type is a springing financial power of attorney. So that requires a physician or 2 physicians to certify that you are incapacitated before your financial power of attorney can be used. It's a balancing act depending on who you name and how much you trust that person. I have had clients where it's been really helpful to have the physician's statements. I've had a nursing home call and say, hey, we need you to authorize this individual's care. I said, well, I think he really wants to start. And I said, well, why? If he really wants to start, it sounds like he's got the capacity to make those decisions. So let him sign the documents and let's move on. Oh, well, we didn't realize. We didn't read the document. Alternatively, I've had clients who have called, and this particular woman was her father's power of attorney. She was going to get these 2 physician certificates so she could activate the power of attorney. And in the meantime, her brother took dad in his wheelchair to the bank and had himself added to dad's bank accounts. So he was a co-owner of those accounts. The bank should never have let him, add his son, because we were actively getting certificates to activate the power of attorney, but it is what it is, right? And that point, then you're going into lawsuits and you're going after brother. And again, no one wants that during a time of, stress and crisis. How many people have young children? Okay, a couple. So considering what happens if something were to happen to you, who are those people who can take custody of your children immediately? The most common scenario we think through is, again, you've gone out and gotten into some sort of accident, right? And so your children are home with a babysitter, or perhaps they're old enough that they're home alone, right? And the clock's ticking and it's, midnight, no parents home. 1 a.m., no parents. You start panicking. And so what the, instinct is, call the police, right? And so the police will come. If you have minor kids, in most states, the police will only leave your children with family members. So if you don't have immediate family members that live close to you, or you have immediate family members in which you don't want them to care for your children, you need to have documents in place saying, these are the people that I want to care for my children. And, instructions that your caretaker can find, or your children's caretaker can find, that says, if you can't find me, call these people in this order. They have the proper documentation to stay with my child, and then call the police. So let's pause for a second, just because that's, incapacity planning. So let's take if anyone has questions on planning for incapacity. So this is time before you have passed. All of the documents that we talked about, power of attorney and healthcare directives, when you pass away, they are no longer valid. So anyone have questions about powers of attorney, healthcare directives?
Yeah, just a quick comment on power of attorney. If they have immediate power of attorney, what do they need to do if for some reason myself or my wife are incapacitated or something like that? I mean, they've been in our will, they've got power of attorney, but they just can't walk and start writing checks. I mean, I don't know.
They can.
Maybe they can, which is okay, but the bank's going to say, well, wait a second, you're not on an account. They got to have some kind of proof that they're in the will.
So they don't need the will and power of attorney, completely separate. So your power of attorney is functional while you're living. Your will is functional once you've passed away. So if you become incapacitated, your named agents in your power of attorney take that to the bank, show the bank. If it doesn't have any requirement to show incapacity, then the bank will let them add them to the account as the power of attorney and let them start writing checks. Right, which is the risk of an immediate power of attorney. Oftentimes we have clients who say, okay, I really don't want my people to have to jump through hoops. So he said, keep it immediate, but don't share it with them, right? You don't have to tell someone they're your power of attorney until they need it. So any other incapacity?
So my partner has been hospitalized a couple times, and we're not married and probably won't get married because of her disease. I think she put me as like a spouse to be able to come in, or a significant other. Do those kind of things is that on her record or like on her medical chart for wherever she goes, or do you think that would be hospital specific, and does that ever expire?
Typically hospital specific, so having a healthcare power of attorney, right, a document that you have with you, right, or can pull up, on a digital, document storage platform. So no matter what hospital you're at, look, I have this ability to have access to medical records and make decisions. So, and then that, typically, if it's a general healthcare directive, it should work in most states. But having something that you can keep, right, with you is really important.
I think I'm early in the process, but what's the steps in like procuring a power of attorney?
So many states have ones that you can do online, and we'll talk about DIY options and pros and cons, but reaching out to an attorney and getting some help. And really the advantage is getting that counseling on, does it make sense to make it springing or immediate? Does, what are the banks in your area like, right? How readily available do they accept powers of attorney? So I think there was one more question over here.
As a parent of adult children, do we need a healthcare power of attorney for our children to be able to authorize healthcare?
So that's why one of the reasons we say everyone over the age of 18 needs at least, these incapacity planning documents. I got a panicked phone call on Thursday from a woman whose 41-year-old daughter was hospitalized because of a mental breakdown. The hospital will not talk to the parents at all. They're getting very limited information. None of these documents are in place, and so the parents are now having to go to court to seek guardianship over their daughter. And the guardianship process is the default. If you don't have any of these, your loved ones then need to go to court and say, hey, I need to be appointed to make healthcare decisions, or I need to be appointed to manage someone's financial assets. And the courts take that very seriously because that is removing your rights as a person and giving them to someone else. So that process, here in Maryland, the alleged disabled person is what we call the individual who needs assistance or representation. They get their own attorney, and they can contest the guardianship, which then can lead to a jury trial. So it's not always a fast situation. And when you're thinking about cost of these documents, getting these in place ahead of time is just pennies to what a guardianship case costs. So not only, are families often in crisis when they call about guardianship, but then having to say, okay, well, we have to go through this court process, and it's going to cost $5,000 to $10,000 to do this. So, all right. So talking about what happens when you pass away and the importance of having documents to direct the passing on of your assets. So as I mentioned before, if you don't have a plan, the state you live in has a plan for you. And sometimes that plan works out really well for people. In the state of Maryland, if you've only had one marriage and you have adult children, everything passes to your spouse, and then, passes to your adult children when the spouse passes. That works for most people, one marriage, adult kids. If you're in a blended family, it is divided $100,000 to the spouse, and then the remainder is split between the spouse and the children. If you have minor kids, again, $100,000 to the spouse, split between the parent and the minor kids. Most people I know that have minor kids say, I want it all to my spouse. And my kids can't inherit. So the state default rarely works for people. So having a will or using a trust allows you to decide, what do you want to happen to your stuff? And who do you want to be in charge of it when you pass? So, right, you get to decide who's going to be your personal representative or executor, who would be your trustee if you use a trust. These are the people who are responsible for collecting all the information about your assets, typically then reporting to the court as to these are all the assets that the individual owned if you're going through the probate process. These are all the creditors that we've paid, and then this is how it's been distributed. Similar with the trustee, they just don't have the court reporting requirements. Your trust or your will say who gets what and in what amounts. If there are any procedures, right? So if you have a will, you're going to go through the probate process. That process varies from state to state. Some states have what's called an easy probate process. Maryland's one of those. It is easy in that it's administrative, but it still takes 12 to 18 months. New York, I have a client who has property in New York, and we are going through that process. In the city, it takes 9 to 12 months to just get the letters of authority for the personal representative to start moving forward and have the authority to move assets. So until that time, if all the accounts are frozen and no one can do anything with the assets. So if there are things like a mortgage that needs to be paid, that's coming out of someone's personal pocket. If funeral expenses typically come out of your family members' pockets first because, right, bank accounts are frozen upon death. Trust administration doesn't have the same court process to it. It allows your family members some flexibility and some privacy because they don't have to go through the court process, and they can take the time to divide assets, as they see fit, what works for them. So, talking about the difference between will and trust, I said the majority, right? A will goes through the probate process, which is the state's process for dividing assets. There are a lot of things a will doesn't do, right? It doesn't grant immediate access to accounts that are solely owned. So if you own something with another individual, so spouses jointly own assets, that asset automatically passes on death to the other owner. Homes, right? So typically for married couples, it's the passing of the second spouse that has to go through all this process. Anything owned in your individual name goes through probate. And until the probate process is started, the individuals don't have access to those accounts. Will doesn't cover emergency or temporary situations, as we talked about before, right? A will only becomes active upon your death. Will doesn't include those jointly owned assets that we just talked about. Wills don't do tax planning. So we were joking earlier about planning for taxes, and there are two levels of taxes to think about when you're thinking about estate planning. The first is federal taxes. Right now, the federal estate tax exemption is $13 million. So you each can pass on $13 million to your loved ones without paying any taxes. That number is going to sunset in January of 2026. It will likely be about $6 to $7 million. It's inflation is adjusted, so we don't know where it will land until then. It is a number to just be aware of because it is a number controlled by Congress. And every couple years, they say, we're going to lower the estate tax exemption. $1 million, $2 million, which, depending on where you live, $1 million if you own a home really could impact you. All right, so it's a number to be aware of. It's a number to be aware that how it works, right? Who has control? But, living so close to DC and watching Washington, right? They can't make a whole lot of decisions right now. This is a decision against a lot of their best interests, right? They all have more than $1 to $2 million, so it doesn't go very far. And we'll see what happens in November. That'll have a big impact on what happens. The other set of taxes to be aware of is what's your state taxes, right? Each state has their own. Some states have no estate tax. So Virginia, nothing. DC is $4 million. Maryland's $5 million. So working with an estate planning attorney in your area just to know and understand what are those numbers, and if you're above that threshold, what can you do, right? Because let's be honest, the people that are above the $13 million each, they're really not paying taxes either, right? They're doing planning around that, so they're not having to pay the taxes. So, wills don't include anything that has beneficiary designations. So one way to pass on your assets and avoid probate and avoid, any administrative or less administrative burden is to name beneficiaries. So on any retirement accounts you have, you can also do this on bank accounts. You can name a payable on death beneficiary. So this is a good way to avoid probate if you have adult children who you don't mind receiving, potentially a large lump sum upon your passing. It's pretty easy, right? The children show up with a death certificate or submit a death certificate to the account administrator, and those assets pass on. Talking about assets and kind of an important planning piece, making a list of everything you own and where it's held, right, is really important, and it's becoming more important as we become paperless. So we used to be able to tell people a long time ago, to be able to say, Joel, for a couple months, you'll get statements for everything, right? We'll be able to piece together what the decedent owned based on the statements that come in the mail. Now, with folks getting electronic statements, it's not as easy, right, to piece together where are their accounts, where were they banking, and to find those pieces. And the administrators of those accounts have no obligation to reach out to beneficiaries or tell beneficiaries, that there's an account that needs to be claimed. So one easy thing that you can do on your own is just make a listing of everywhere you have accounts so that your family members know, right? Even better if you have beneficiaries listed on those, list who the beneficiaries are. So that way, when your family member's looking at the administration, they know, okay, these are the things that we're gonna have to go through either trust administration or a probate administration for. These are the things that we can just go and get access to right away. The last thing is wills don't provide any privacy. If it's important to you that folks don't know what your family members are inheriting, wills are public records. You can go online to most of the county wills, register of wills, and pull the information, either pull copies of the will, pull copies of who gets what in what amounts, so those accountings. So if privacy's a big thing to you, or if the folks inheriting are vulnerable adults or vulnerable individuals, what we're seeing, the problem we're seeing here is scams, right? It's not, average everyday people aren't going to read wills, right, to see what's going on in other people's lives. It is bad actors who are looking for individuals who have inherited a lot of money and who may be vulnerable to scams. All right, so a little bit about revocable living trusts. Revocable living trusts are the way that we avoid probate. So they are a way that you retitle your assets. The trust is then the owner of the assets, and so you're able to avoid probate. You're able to put in some flexibility, right? So if you have minor children, or if you have children who are young adults and you don't think that having them inherit a lump sum at an early age is a smart idea, you can put terms in that trust to say, you know what, I want my kids to inherit a third at 25, a third at 30, a third at 35. So they're not getting a check for, even $200,000 for a 21-year-old is a lot of money, right? And 21-year-olds aren't known for making the best financial decisions. So putting in some parameters there and adding in some flexibility is one of the things that you can do with the trust. And then most of the time, trusts save your loved ones time and money, right? They're not having to go through the probate process, and so they are not going through the administrative pieces for that process, right? They're often able to then go to an attorney's office and walk through the process privately on their own timeline. Trusts are completely private. No one needs to know who inherits what. Even when you retitle accounts into the name of a trust, right? You have to go to a bank and say, bank, I have a trust. I want my bank accounts to be owned by this trust. They're entitled to a couple pages from the trust, but not the entire thing. Then the other advantage of a trust is if those accounts are owned by the trust, you are relying on the trust and the trust document and not powers of attorney if you become incapacitated. There are some banks that make using powers of attorney very difficult. And one of them, I was on the phone trying to get them to accept a power of attorney. And they said, well, you know, there are easier ways to do this. And I said, I know, but my client is incapacitated and we can't use any of those easier ways. So by having the account owned by the trust, the successor trustees, if you become incapacitated, can then manage those accounts on your behalf. And those accounts are immediately available upon your death. The other type of trust I wanted to touch on today are supplemental needs trusts. So supplemental needs trusts are used for individuals that are receiving government assistance. So if you're receiving government assistance in which you can only have a certain amount of assets, right? So, you know, for Medicaid purposes or Social Security purposes, if you inherit money, right, you can get kicked off those benefits and services. So using a supplemental needs trust, either setting one up ahead of time for a loved one so they have additional funds to support their lifestyle, to support their life while not losing their government benefits they're entitled to, or making sure it's included in a will or a trust so that it's created upon your death. It goes immediately into a supplemental needs trust and not to the individual, which would then kick the individual off their services for a period of time. So I'm going to just a couple more slides about costs, and then we'll move on to questions. So, you know, estate planning is one of those things that kind of runs the gamut of costs. There are lots of services out there where you can DIY an estate plan. Will and trust, trust and estates, LegalZoom, Mama Bear, and it seems like a new one comes up every day. And oftentimes, what I see when I review those documents is folks have filled in the blanks and they've put in all the pieces and they think it does what they want it to do. But what pops out is either something that's so full of legal jargon that it's hard for the average person to read, or what comes out is not what they wanted. So I've reviewed wills where a gentleman left everything to his cat. You can't leave things to your pets. They can't inherit property. I had a gentleman who left books and records and some personal property to both his daughters and his girlfriend. At that point, right, it just creates conflict in the end, and you can't ask the individual, hey, what'd you want? What do you mean, right? And so if there's conflict, it then goes right back to court and becomes a mess. So I don't think DIY trusts or DIY wills, I would not DIY a trust, but DIY wills are a bad thing if you're in a time crunch, but it's also one of those, you get what you pay for, right? And perhaps spending a little bit more money and working with an attorney to make sure that your wishes are documented correctly, to make sure that you are getting what you need, so that on the other end, right, your family members aren't paying for potential conflict, paying for confusion. I think wills versus trust really depends on what your goals are, and the cost evens out in the end, right? Wills are typically cheaper to do now, but the probate costs can, kind of settle that in the end. There are lots of attorneys out there. There are lots of attorneys that will do just about anything. We call them door lawyers. If you use an attorney, please use one that specializes in estate planning and they just do estate planning, because again, you might as well go to LegalZoom and do your own, because if you don't have someone that specializes and knows what they're doing, you know, you could end up with the same mess as if you did it your own. All right, that's all I have on information. I know it's a lot, so feel free to ask questions.
Yeah, I'm assuming that powers of attorney, whether financial or medical, are null and void at time of death?
Correct.
Okay. And from a trust point, or not a trust, from an estate point of view, once the will is probated, is there a time limit on the estate to get settled?
Depends on it depends on a lot of factors, right? It depends on how long does it take to sell things. If there's a estate can go on for a long period of time, right? And typically, right, the process is, you know, once the creditor's claim period has run, your executor is able to wrap up the estate. But what if it takes forever to sell the house? What if there is a lawsuit, right? What if, you know, some states stay open because you're anticipating a judgment to come in, right? You were part of a lawsuit and you're anticipating a settlement, but who knows when that settlement's coming in? We have a number of those that are opened for the Camp Lejeune water situation, and they will stay open until the settlement's made. During that time, the executor will have to report to the court, depending on what state it is, but typically every 6 months. This is what's happening. Here's the accounting, here's what's come in, here's what's come out, here's the expenses. You're back in the corner.
So could you touch a little bit more on the supplemental needs trust? I have a daughter who's disabled, is on Social Security disability. I've been loath to add her as a beneficiary to anything. And I'm not quite sure, like in that situation, do I establish a trust and then the trust becomes a beneficiary? A little more info
Yeah.
would be very helpful. Thank you.
Yeah. So that, you've got it exactly right? So establishing a special needs trust for a loved one and doing it as a parent, right, or as a third party is actually preferable than an individual doing it themselves. So you can establish a special needs trust for her and then name that trust as the beneficiary on any accounts. And so then when you pass away, you know, someone shows up with the death certificate and it goes into that special needs trust. And in that, it gives you control, again, to what if that money's not all used? Who does it go to then, right? Where if an individual inherits and they have to create their own special needs trust, then the government typically has to be the primary beneficiary on whatever's left over. Any other?
For assets owned by two people that aren't married, does that also for assets jointly owned for unmarried couples? If one of them dies, does the other owner?
Other owner becomes
sole
owner
owner?
automatically.
Okay.
Yeah. Howard?
I just want to make a comment. I'm also an attorney. You never want to do your own document. You really don't. And it's not, we're not biased because we're attorneys. As an example, it happens all the time with a power of attorney. Someone has a springing power, she called. You know, they can't take care of themselves. We sometimes call it a durable power of attorney. So somebody has a mutual fund and they have to cash in some of it. So they send Fidelity this power of attorney, and the power of attorney is 5 years old. And Fidelity refuses to honor it. So imagine if you did it yourself. There's nothing you can do. So if you had an attorney draft it, you go back to Megan, she writes a letter that the trust is still in full force and effect, and your problems are over. So just never do it yourself. That's my only comment.
Yeah. And I think, you know, so Maryland, as I said, there's some states have self-help options, right? Maryland has a power of attorney. You can go on and do it yourself. It was just recently updated with some great enhancements for planning, especially planning for Medicaid planning and planning for seniors. But in doing that, they've added a whole bunch of check boxes and a whole bunch of places where you can initial. And if you don't know what you're doing, if you don't know how to check those boxes, you can inadvertently give someone powers that you wouldn't want, right? The power to gift unlimited to whoever you want. And, legal language, we try to keep it straightforward, but sometimes it's just a lot, right? It's a lot to read, it's a lot to get through. So even where there are self-help options, at least going and speaking to an attorney to try to figure out what it means is helpful. So.
Okay, so let's say a trust is set up, and then you're moving states, or maybe you don't even actually have residence at the time you pass. Does that make any difference whatsoever?
If you have a trust, so let's talk about trusts and funding trusts, putting things into the trust. And I think that's part of it. If you move states, the trust should be good in all 50 states. It should be recognized by all 50 states. We always recommend that if you change states, to meet with a state planning attorney just to have your documents looked over, to see if, are there any weird things about that state you moved into that may impact your plan, right? Maryland has an inheritance tax. So if you are giving to anyone outside of your immediate family, they pay a tax, the state calls it for the privilege of inheriting property, of 10%. So if you give outside, if you don't give to your parents, your spouse, your siblings, or your children, everyone else, 10%. They just changed that for folks that are not married, but living together as domestic partners or living together and financially supporting each other. And so you now can file a document. So for estate planning purposes only, you are considered a spouse. But if you moved and you didn't know that, you didn't know you could take advantage for, one filing and $25.
So you just answered the question for trust and you switch states. What about a will? If you have wills and you move to a different
Yep.
state?
So your will should also, be valid, however, for the same reason, right? Check to just see is there something weird about your state or new state. So, and then what I was saying, one thing that the gentleman brought up that triggered about trusts and that I see often with DIY trusts is they don't get funded. Funding a trust means retitling accounts, retitling property, have that trust becoming the owner of those assets. Because if you don't do that, you've paid for a lot of expensive pieces of paper and your family's still going through probate and following the directions of your will.
What's the difference between a revocable trust and an irrevocable trust?
It's change in control. So who controls the assets and what limitations are there on changes? So irrevocable trusts, typically the people creating the trusts are not also the trustees. They're not the ones managing the assets, and changes are very limited in an irrevocable trust. Irrevocable trusts are most often used for tax planning purposes because you no longer are the owner, so it's not part of your taxable estate. The other time we use them is for Medicaid planning. So looking forward 5 years and anticipating the potential need to qualify for Medicaid, using an irrevocable trust to take assets out of individuals, out of their names. And then revocable trusts, right? You can make changes whenever you want, as long as you have capacity and are able to, communicate with the attorney to help you make the changes. You can make changes at any time.
Is there a way of searching for reputable and credible estate planning lawyers? Can you suggest of a website or a search engine, or do we have to look for any credentials to make sure that we're dealing with like credible lawyers?
Great question. So, so at the end of the session, one of the things I brought up, because I know that this is the hardest thing, one of the hardest things to do, is finding someone. So if you're interested in being connected with an estate planning attorney, if you leave me your name and email address and what state and city you're in, I'm part of a network of estate planning attorneys, and so I will connect you or send you names of individuals. There is, I think it's estateplanning.com, which is run by an organization called Wealth Council. They have a database of estate planning attorneys who typically only practice estate planning. The National Association of Elder Law Attorneys is also another resource, and they have, typically elder law attorneys also practice estate planning. So it's another database you can go in and search for someone in your area.
Just, you kind of triggered a thought. If your accounts have beneficiaries and your will states there's a trust, who wins?
Beneficiaries. Beneficiary designations always win. So, and I've had that happen in a probate I'm working on where blended family, and the personal representative in the estate called me the other day and said, well, I just went to go find the bank account so we could start the accounting, and I found out that my ex-husband's daughter went and she was named as a beneficiary on all the accounts. Took over $200,000, and now we're in a situation saying, well, we might not be able to make up what his spouse is entitled to under state law without some difficult conversations like asking a grandchild to sell his car. So that's why doing this, right? Because this really is for your family and your loved ones, and making sure if something happens to you, they're not left, right, handling a mess. That they know, right, everyone knows where everything is, and the process comes with no surprises, or as few as possible.
Are there costs to putting like land, house, residence type property or automobiles into trusts? Like aren't you actually kind of selling your property to the trust, and so you have to pay?
Most states have an exemption. Most states allow you to put property into a trust as part of an estate plan. Similarly, if you have a mortgage on the property, there's an exemption, and so the banks can't call that mortgage because you're doing it as part of a estate plan. Go ahead.
I think that it's just really important. I was in a coma for 5 months, and my husband didn't really know what to do with a lot of things, and it just came on, my anti-MDA5 came on so sudden that we didn't have anything planned. Like, we had just had minimal conversations about what happens if we die, because I'm only 53. So there were just so many things. We still haven't done it, but I just think those conversations are super important and for people to get started with.
Yeah, and even if, I mean, those types of conversations, right? That's they're not comfortable conversations to have. But if you think about it as, this is a gift I'm giving to my family members, right? Because that way your husband at least would have known, like, oh, this is exactly what's going on and what we need to do, and this is the time period. And not having to second guess, right? Or if there's conflict, I think everyone probably remembers Terry Schiavo here, right? And she was in the hospital, and the conflict there, right, was her husband and she had no documents. Her husband and her parents were in conflict. And so the hospital said, great, go to court and figure it out. And that court battle lasted 15 years. Long enough that her husband sought an annulment so he could get remarried. And that's the importance, right? You never know. You never know when people are in times of stress, in times of grief, what personalities are going to come out, what conflict will come out, right? You always think, when I talk to people that have multiple adult children, they go, oh, my kids always get along. I'm going to name them. They'll be joint everything, and they'll get along all the time. Like, what? Like, have you thought of a time when they haven't got along? Like, have they always gotten along? And so maybe, at that point you pick, right? And maybe if you don't want to divide, it's someone gets healthcare decisions, someone gets financial decisions. And that way you're still being fair, but it reduces the chance of conflict and reduces the chance that you're sitting and waiting, or your family members are sitting and waiting for their inheritance while the court figures it out.
So once you have your will or trust put together, how often should you revisit that?
Yeah, so we like to review it or tell people to review it every 3 years. So just to make sure, right, that everything's still where you want it to be, right? The people you've named, and it doesn't have to be an in-depth review. Take a look. Are the people you named to be in charge still the people that you want to be in charge, right? Did you happen to name your sister and now you're not talking to each other? Well, maybe you want to make an update then, right? The most often, right, so we see people do estate planning when they have small kids. And then the next major update we see is when their kids have become, young adults, mid-20s, late 30s, right? The age in which you feel comfortable that your adult children can make decisions for you. That might be 25, that might be 35 or 40. And then again, right, when you're retired and you're looking at maybe some planning for retirement, do we need to take another look? Do we need to look at what our asset profile is? Are there any estate tax, considerations, anything we need to do? And sometimes estate tax planning is as simple as you got to go spend some money, right? I talked to a woman the other day and said, you need to go put a new roof on your house and get all that house stuff to do, because you don't have a lot you have to spend down, but you need to spend some money. So all right, well, we've got a couple minutes, give you a couple minutes back to your day. Thank you all, this was great.